Just to introduce myself really quickly, I'm Katie. I'm part of the All Raise team. We're so excited to have you on this webinar. I know there's a lot of information that we're going to cover today, so hopefully it is of use and just helpful in your process through these really uncertain times. I just wanted to go over a couple of housekeeping things to start. So at the bottom of your screen, if you are an attendee for this webinar, there's both a chat function, which you can send messages to everybody, introduce yourself. We love seeing those introductions. And then there's also a Q&A feature. And if you have questions of the panelists, feel free to drop things in there and we'll get to them hopefully throughout the session. But we also got your questions before the panel too, and we'll be trying to address those questions in advance as well. So thank you for coming to this webinar. I wanted to introduce all of our speakers today. So we have Blake Ilstrup, who is a partner in Orrick's Technology Companies Group and a lead for Orrick's SBA loan team. We have Justin Field, who is the SVP, sorry, of Government Affairs at the NVCA. And we have Laura Bloxham, who is a Senior Associate in the Technologies Company Group at Orrick and a member of Orrick's All Raise team and the SBA loans teams. And we also have Lily Becker, who is a partner in Orrick's White Collar Investigations, Securities Litigation, and Compliance Practice Group. Thank you all for being here. We're super excited to hear from you. So I'm going to kick it over to the panel and you all can get started on this huge stimulus act that the government is currently proposing.
Thanks, Katie. Do you want to put up the slides that we had?
Yes.
Awesome. So I'll get started. My name is Laura Bloxham. As Katie mentioned, I'm a senior associate in Orrick's Technology Companies Group. I work closely with Blake, who's also on the panel, and several other lawyers up and down the West Coast and throughout the country. We represent founders and startups in everything from through venture financings and into exits with their business. Startup representation and founder work is probably about 80% of our practice. We also do a little bit of VC side representation, and so we're deeply immersed in this market, which at the moment means that we're deeply immersed in the CARES Act, and in particular some of the SBA loan funding that a lot of our clients are trying to access right now, and a lot of venture investors are taking a very close look at as well. So I'll let Blake introduce himself. We, when the CARES Act first came out, put together a task force of attorneys internally to look at the CARES Act and try to untangle some of the concepts in there that that impact our clients, and Blake has really been leading the charge on that. Katie, do you want to put up the next slide?
Oh my goodness, there we are. Thank you, Laura. Yeah, my name is Blake Gilstrip. Again, I'm a partner in the Seattle office of Orrick. Laura and I both work in the Technology Companies Group. As she mentioned, about 5 weeks ago when we saw this legislation moving forward, we put together a task group of about 12 lawyers across the firm. If you don't know, Orrick is a huge firm. We're a global firm, about 1,100 lawyers and 25 offices worldwide. The TCG is a much smaller practice group. And then, you know, the SBA loan team is a cross-practice group of lawyers who are helping our clients in all sectors navigate the CARES Act, most notably the loan programs. What you're seeing right here is an infographic that's available on our resource center on our website. I would encourage you, if you have questions about any of these things, to visit our website. I'm a little biased, but I think it's a really well done, well-resourced site. This is on there. It's kind of a one-page summary of the Paycheck Protection Loan, the PPP program. I also wanted to mention that there is another loan program that a lot of our clients are looking at called the Economic Injury Disaster Loan Program, EID. That was actually a pre-existing SBA program for you know, disaster funding like we're experiencing right now. That one's not getting as much attention because the terms are not quite as favorable as the PPP. Although for some folks it may be a good resource. That one is a loan amount of up to $2 million, and the interest rates are pretty favorable. They're about 3.75% for small businesses. You do have to provide a personal guarantee for loans over $200,000. You may have to also provide collateral. But that one, in terms of its use of funds, is pretty broad. You can use that for general operating purposes, including payroll, but other things beyond that. That program does not have forgiveness like the PPP does. And that one you can apply directly through the SBA on their website at home.treasury.gov. That's actually a pretty good website. I wanted to pitch that for a minute too. If you go to home.treasury.gov, it's a surprisingly good set of aggregated resources for not only these loan programs, but the other, tax deferral programs and small business counseling. So I'd encourage you to check that out. So this slide again is a summary, kind of all the information in one place about the PPP loans, which everyone is interested in, at least in the tech startup community and venture-backed company ecosystem. Those loan amounts are based on payroll, so it's 250% of the company's average monthly eligible payroll costs over the last 12 months, not to exceed $10 million. Interest rate of 1% and a 2-year term. All of those are going to have the same loan terms, regardless of which lender you go to. There's no personal guarantees or collateral. The catch here is that you have to use the loan proceeds for payroll and rent and utilities. And to the extent you use them for those purposes, all of those amounts are forgivable. So again, you have to use it for eligible payroll. You can use it for health benefits, interest on mortgages if you have a mortgage, rent, utilities, as well as interest on pre-existing debt. You can't pay down principal on existing debt, but you can pay interest. All of those amounts, except that last one, the interest on pre-existing debt, is forgivable. And it's based on sort of your use of those proceeds for those purposes in the 8 weeks following the date you get the money. And then the loan, one thing to keep in mind though is the loan forgiveness amount is subject to reduction if you lay people off during that period or cut salaries by more than 25% for folks who make more than 100K on an annualized basis. These loans you apply not through the SBA, but through SBA approved banks. We're encouraging people to talk to their existing bank, and I'll talk a little bit more about the application process in a little bit. One thing that's important to note here is that these are designed for small businesses. And so generally speaking, that's a business of 500 employees or less, which for most, tech startup companies seems, achievable. The problem though is that the SBA has certain affiliation rules, which would aggregate the employees of affiliates, in some cases, including venture capital and private equity investors. You'd have to aggregate not only the fund employees, but their portfolio companies. And so Laura was going to go over real quick the affiliation rules and kind of what to watch out for on the next slide.
Thanks, Blake. So this is a topic that's really hot in the market right now because, as Blake mentioned, the PPP loans are very favorable terms, and a lot of small companies want to access those loans. However, the affiliation rules are impacting, in particular, companies that have any VC or private equity backing. The affiliation rules are not a super cut and dried thing. The CARES Act didn't come down with a very specific definition about whether or not you are affiliated with an investor. And so we've been looking at prior SBA programs, guidance, case law, and a number of different resources to help our clients navigate this concept of affiliation and whether or not they might be implicated by these rules. So generally, there's a couple things to look for. If you have a venture fund or a PE fund that holds more than 50% of a company, it's an affiliate. And if that is the case, then a lot of companies will fail the small business test because of the aggregation of their employees with the investor's employees and the employees of any other companies that the investor controls. So a lot of companies think, great, my ownership is more diverse than that. I don't have anybody who controls an outright majority of my shares, so I'm in the clear. Unfortunately, that's not quite the case either. The SBA has historically found companies to be affiliated with certain investors based on control rights that are embedded in the formation and investor documents of the company. And so there's a complex analysis that actually needs to be done when looking at this question of affiliate and whether or not you are forced to aggregate together with any of your investors for the purposes of meeting the small business requirement. Historically, the SBA has looked at things that they considered sort of day-to-day control rights, such as incurring debt or entering into contracts or declaring dividends, as things that tend to show affiliation. Conversely, some of the bigger corporate decisions that a company will face in its lifetime, like whether or not to engage in a merger transaction or file for bankruptcy or make changes to the authorized capital and issue new shares of the company, those are considered more investor type concerns, where it's not a day-to-day control right. It's something that the investor, even if they're not affiliated with the company, has a legitimate economic interest in controlling. So it's a bit counterintuitive for founders and companies looking at this question, because some of the biggest control rights that investors have are actually things that don't rank that high on the risk scale with regards to the SBA in particular. So we've been helping companies with this analysis. Many of the things that are high-risk control rights are things that we see come up regularly in ordinary course venture financing documents, whether that's in a company's protective provisions under their charter or their investor rights agreement or some of the other documents. So once we've run this analysis with companies, many venture investors at the moment are showing an appetite to work with companies to help modify or reduce some of the control rights under the documents in order to enable the companies to access the SBA funds. So there's really kind of a three-part process here. The first part is, does anyone outright own a controlling stake in the company? And then if not, you have to pass to this more complex analysis of whether there are any contractual or other sort of control rights that might make an investor considered a deemed affiliate. And if that is the case, then you have to work with the investors to see whether or not any changes to the structure or changes to the documents are merited and available in order to help the company access the funds that are needed. One thing that we've rolled out recently to help with this process is a flat fee tool that you can find on our website, and perhaps we can circulate the link to that as well. If you're looking at the SBA loan eligibility and trying to figure out whether or not you get tripped up in these affiliation rules, whether or not you're an existing Orrick client, we are offering currently a flat fee to run the analysis with you if you send over your cap table and your constitutive documents. We have a team of folks who can run the analysis pretty quickly and efficiently to help you understand whether or not you're eligible, whether or not the affiliation rules apply, and if so, some suggestions around what you can do to help to get to the next step, which is the PPP application. I think Blake is going to talk more about that.
Yeah, thanks, Laura. And so on the next slide, just some updates on the application and some of the mechanics and market dynamics we're seeing. The form of loan application for the PPP is available on Treasury's website. Check that out. There's also a link from our resource page. Some banks are using modified forms of that, but I think if you're considering applying for this loan, you should go check that out because it has a series of information requests on it, including names, tax ID numbers, and addresses of all 20% plus owners. And certain certifications you need to make that, give a lot of people pause, especially venture-backed company, entrepreneurs. And so take a look at that. We can certainly help walk through those issues on that application form. The banks were advertising that they'd be ready on April 3rd. I think we're just now getting to the point where banks are actually able to process these applications. I have heard of quite a few of our clients in the last 48, 72 hours actually receiving funds. So if you think about it, it took a long time to ramp this thing up. A lot of the banks were very confused by some of the requirements, but I think things are working better now. We're advising our clients really to start with your current bank, your current commercial bank, if they are participating. And to participate, they have to be an SBA approved lender. Because they're going to prioritize current clients over others. In fact, some banks aren't even taking applications from non-clients at this point because of the volume. We spoke to SVB the other day, and they're currently processing 30,000 applications that came in over a 48-hour period. Having diligence materials ready will streamline the process. For the PPP, that mainly means payroll data, because they're going to want to validate how you've calculated the average monthly payroll over the last 12 months. So you'll have to have that data available. Charter documents, financing documents, obviously financial statements, things like that. Having those ready will help the process. The one thing I would say about the application is it looks straightforward. It's only 2 pages, but it can be pretty problematic, especially, as I mentioned earlier, if you have institutional investors who own material amounts of the company. So like I said, you have to disclose all 20% plus owners, including their tax ID numbers and addresses. And you also have to disclose those owners' other companies, other portfolio companies. And there's sort of varying approaches people are taking to that, depending on if there's an affiliation issue or not, and the risk tolerance of those investors. You can imagine a lot of people are not excited about listing non-applicant information on these applications. And we are recommending in some cases that, to the extent those companies are listed, that you drop a FOIA notice on the addendum to make sure that that doesn't get disclosed by the SBA if someone did a FOIA request. So that's the PPP loan application and the summary generally. Let us know if we can help. Like I said, our resource page I think is pretty good. The Treasury's website is really good. And I look forward to taking any questions at the end of the session. I think we were going to turn this over to my partner, Lily Becker, who's a white collar and investigations attorney, because as you can imagine, these loan programs and in times of crisis like this come with a lot of liability in varying flavors. And so Lily's going to cover some of the issues that come up around that.
Great, thanks, Blake. So apologies in advance for any of my coworkers here bursting in. It's been a little bit of a rough morning. So as Blake mentioned, I'm in the San Francisco and Seattle offices, and yeah, focus on white collar crime, fraud defense across securities litigation and criminal actions, and also help companies put in place compliance programs. So I'll just talk a little bit today about some steps you can take to try to mitigate any risks that you may face now or in the future. Okay, next slide. Great, so unfortunately, what we have right now is what we're calling a perfect storm for fraud and corruption. Certainly all of you are focused on the immediate crisis, which makes perfect sense. But there's obviously a lot of pressure, and sometimes pressure leads employees to do bad things. Another thing to think about is in the course of applying for all the loans that Blake and Laura mentioned, these will be statements to the government, and it's against the law to make a false statement to the government. So just to make sure that you are really taking into account all the facts you have at hand when you put together those applications. Another thing to consider are any representations made to insurance companies during this time. So like I said, we'll go through a few things outside of just making sure that everything you're saying is accurate that you can do right now to mitigate risk. So next slide, please. Here's some basics. If you don't recall some of your fraud and corporate governance primers, but fraud is basically making or concealing a material fact. There is both criminal and civil liability. And so I talked through a little bit of those issues on the last slide. Also keep in mind some of your corporate governance basics to avoid some shareholder litigation. So, you know, as I said, focusing on the accuracy of your public statements, really anything that's made, even a press release, disclosures and financial reporting. And keep in mind some of the basic principles like setting a good tone at the top and keeping in mind your fiduciary duties. All right, next slide. So here's something that you can do now to try to mitigate risk, ensuring that everyone at the company can spot problems. Often bad acts will go unnoticed in the confusion. And in addition to spotting the problems, you also want to create a culture that people feel free to escalate when they see something wrong, and that they won't have any blowback or retaliation for themselves. And what we like to do is use examples that really resonate. So any training or conversations, if you don't want to have formal training, would be to use examples, hypotheticals that you could consider for your particular business. Okay. And then another thing that's pretty simple that you can do is when you're sending out messages internally to just reemphasize the the company's principle that you always act ethically, and so this can be in particular important if you're talking to folks about meeting their numbers, because that's really where we see that it can be misinterpreted by people, and then the government can really focus on those messages if you end up having to defend yourself in front of them. And so here's a few ideas. You certainly want to acknowledge the pressure and the risk that's going on, but just really reinforce the ethical standards that you expect within your company. Okay, I think that's it for me.
So that's a lot of, yeah, so I was going to say that's high level information that's really tactical about these programs, the PPP in particular under the CARES Act, everything from the logistics of how to apply to the governance considerations, and then of course the internal dynamics and ethical considerations. And I think at this point we wanted to turn it over to Justin from the NVCA, who's been a great thought leader in this area as we continue to kind of untangle these rules and regulations, to zoom out a bit and look at more of the theoretical and policy concerns around the Act.
Great, sure. Can everyone hear me? Mm-hmm. Awesome. Well, thank you all very much. A couple quick things I wanted to see if you guys had some thoughts on. The EIDL program, I think, still operates under the 103 affiliation rules as well, right? So I think, because all the changes that we did, we focused our efforts on PPP, right? So that's where we got the personal guarantee kicked out. That's where we got the 301 rules turned on. But I don't think either of those came over to EIDL. And EIDL, I think personal guarantee is for loans over 200,000, but I also think folks are going to have a lot of challenges with affiliation with EIDL loans too, right?
That's very true. Yeah, the affiliation rules as amended by the CARES Act apply to all of those programs. So you either have to qualify as a small business under the existing SBA guidelines, or you can try and meet this 500 employee or less test, but that applies to both.
Yeah. So you could, if I know this correctly, you could theoretically be eligible for PPP under affiliation and yet not EIDL.
I believe that's yes. I believe that's true. Mm-hmm.
Okay. Yeah. I hadn't gotten confident, but I thought that was right. Just the other thing I want to touch on was the forgivability aspect as well of the loans. Payroll is still fully forgivable, but the application had this section where it said, and this was a deviation from the statute, but said, because of high demand, we may only refund or forgive loans that are used for rent utilities up to 25%. It wasn't a hard and fast, but just that was one thing that I was kind of interested in, because it was a pretty significant deviation from the statute there. But it leads me to believe that if you are taking these loans and hoping for forgivability, you probably want to ensure that you're stacking that cash first on payroll, because rent utilities you may not get forgiven for even if you do it correctly.
That's exactly right. Yeah, and we haven't seen how that's going to pan out as these loans mature to the 8-week period, because that's when it's going to be measured, right? Right. In terms of your use of proceeds during that 8-week period. But the theory right now is that they're going to limit that forgiveness amount to, you have to use at least 75% of it for payroll, because the whole policy purpose of the PPP program is to keep people employed on the payroll.
Right. Right. Add it to the list of questions that continue to arise every single day on all these things. Look, you got to give folks, I think, some credit, because this is a crisis, and in a crisis, things move very fast. I was on the Hill in 2008, 2009, 2010 during the financial crisis when we passed TARP, stimulus, and the Affordable Care Act in consecutive years. And if you add all those three up, they're still not in cumulative amount as large as the CARES Act, which is about $2.3 trillion, just to kind of show you the size of this package. I've been in Washington for 20 years. There's never been a spending package that's even been close to this other than your annual appropriation. This actually exceeds total annual discretionary appropriations for the year, which is a pretty stunning thing to say in a piece of legislation. In terms of what you all should be looking out for, I think the Orrick team here did a fantastic job walking through PPP, and I know it's a difficult set of circumstances, right? It's not just one subjective challenge you're dealing with; it's two, right? Between affiliation and the definition of need, which is an impossible question in many ways to determine, right? Because you mess it up on one side and you look like you're taking money away from independent small business. You mess up on the other side and you're laying people off when you could have saved their jobs. So, it's these difficult challenges that come up in times of crisis that you just have to rely on your good attorneys like the ones on here and hope for your good faith to make the best decisions. I'll leave that aside since I think you guys did a great job covering a lot of it. Other than to say, we do believe that negotiations are ongoing for a further infusion of capital into the program. Right now, there's $350 billion that's been put into the program. Congress has teed up another $250 billion to go in. There's an open debate right now between the parties as to whether or not that $250 billion infusion legislation should carry with it additional funds for states and municipalities and hospitals, et cetera, as well, or should it just ride cleanly on its own? We're not doing anything on affiliation in this. This is an argument, a philosophical debate that's far above our pay grades here, and we tend to think that it's more likely than not that whatever they figure out, whether it's clean funds just for the small business program or whether there's additional funds for other entities in need, that's something that they're going to have to figure out at the highest political levels, and they'll come back to affiliation at some other time. So our strategy here is just to take a step back, monitor what's going on, talk to all the stakeholders, VCs, startups, banks, lawyers, et cetera, and see what's going on so we can develop a list that we can bring in a couple of weeks once they've gotten past this and say either this program is working or it's not, and here's where we found the evidence and the data for that. So from a broader perspective, there are several other pieces of the CARES Act that I think startup companies should be interested in. And if you're not doing PPP, you should definitely be taking a look at the employee retention credit. If your company has experienced a loss of revenues over 50% relative to the same quarter from the year before, or if you've been forced to close due to a government order. The employee retention credit, which you cannot use if you are also applying for PPP or have been approved for a loan of PPP. But if you are not, you can access this credit provided you fit the criteria, and it's up to $5,000 per worker. If you're under 100 employees, it counts for pretty much every single worker. If you're over 100 employees, then it's only for workers who are on the job but can't actually work because of COVID-19. It's definitely a resource out there that you should check if you feel shut out of PPP. What everybody should be looking at right now and make sure they have in place is deferral of payroll taxes. So there's another provision in the CARES Act that allows companies to defer their payroll taxes until the end of the year. If you're in PPP, when you become eligible for forgiveness, you are no longer allowed to defer payroll taxes. But that means that up until you get there, and we requested for clarification on this from Treasury and got some very good news on this on Friday. So if you are applying for PPP, you can still defer payroll taxes according to the FAQs that came out Friday, and I'm happy to share them. You can still defer these payroll taxes until you become eligible for the forgiveness aspect of PPP. So you should definitely be talking to your payroll provider or whoever's managing that and asking them, are they taking a look at this? Because even if you are in the loan forgiveness part of PPP, you just don't get to defer your payroll taxes for the rest of the year. But even the payroll taxes that you deferred up until then, you don't have to pay back until half in 2021 and half in 2022. So those are the two tax pieces that I think people should have on their radar screen. I think there's another piece for those making the very difficult choice between furloughing or laying off workers. Unemployment insurance under CARES Act will allow access from people who have been furloughed, not just those who have been laid off. And so there is an opportunity for folks, if you want to provide them healthcare benefit, continue to provide them healthcare and benefits, furlough them, they can access unemployment insurance, and then obviously a lot easier to come back on the rolls. Finally, I think the other big thing that is getting rolled out now and is probably looking a little bit more likely to be accessible for growth stage companies, and that's if a few things get fixed in it, is this Main Street loan facility. And these are loans, somewhere between I think 3 to 4.5%, not forgivable, but 95% guaranteed by a Fed facility, or they'll buy 95% of loans off the banks. And they can be anywhere from $1 million to $25 million in working capital. You can't use them to offset debt or pay down other types of debt, but if you do need money for working capital, they are available. The two main gating challenges, the one sort of existential gating challenge right now is that maximum loan size is keyed off of EBITDA. So you have to have been profitable in order to actually access the formula for maximum loan size. That's clearly a non-starter for probably 99.9% of the companies we're talking about in this forum. But it is something that we're engaging on and asking them to come up with an alternative test that works for companies who are in their growth phases. There's another significant question as to whether or not, if we were to get that fixed, there's a prohibition on distributions for companies up to 12 months after they repay the debt. And so one piece of clarification that we're also interested in is, well, wait a second, if you have an acquisition that pays down the debt, do you really still have to wait a year to provide liquidity to your LPs? Which wouldn't seem to make a whole lot of sense, especially if the entity's kind of has gone out of existence. But it's something that, if you read the text and the guidance, is clearly an open question, and it could be interpreted a way that would make it less attractive to venture-backed companies. That's only if we get the EBITDA test thing fixed. So, it's kind of like a different program, whole new set of challenges to try to make this thing work for the startup ecosystem. And then I guess finally, the last thing I'd flag is we're going to probably see additional bills coming through the Congress on these issues and figuring out how to provide economic relief to an economy in crisis. And I think we will hopefully have a chance to try to get some sort of program that is actually designed for the growth company model, rather than going in there and trying to fix, things that come from a very dated view of the economy. If you look at all these tools, they come from this perspective. You have existing large enterprises, you have independently owned small businesses, and you have individuals and families. And those are the way the tools are kind of built. And this whole idea, we have a growth company with revenues, it's research intensive, doesn't really fit into that, because on the scaling way, it's a relatively new concept. And I think a lot of these economic crisis tools are pulled off the shelf from somewhat dated models. And so hopefully we can have a chance in this next round to put something forward that can actually target these types of growth companies like we've seen in other countries, right? Where that are putting together startup funds just for these companies. One idea that we're exploring and we're working on right now is, could we allow startups to monetize their tax assets? Right, so your R&D credits that are on your books, your net operating losses that are on your books, there's a book value to those, right? If you have $100,000 in NOLs on your books, they're actually worth $21,000 because that's the corporate rate. Could Treasury start allowing you to monetize those in your R&D credits? They did something similarly for existing companies in the CARES Act when they allowed companies to carry back the losses generated in this quarter to offset previous year's tax payments, as well as allowed companies with excess AMT credits to monetize those. So we think it would be a logical next step. Again, they have a million challenges that they're dealing with. We are, you know, whereas long-term, we are an incredibly significant part of the economy. In overall size and immediate impact, we look relatively small. So that's why we're often sort of passed over. So we're hoping that we can get some airspace here for ideas like that or others that I think can deliver impact in a more carefully curated way to the companies that we really care about here. That's most of what I had. Do you guys want anything else, or maybe take a stop there?
Justin, I had a question for you. Getting back to the PPP, there's this requirement that the applicant certify that the loan is necessary to conduct ongoing operations in light of COVID-19.
Yeah.
And there's a lot of chatter in our ecosystem about what that means. I mean, it's not defined at all in the CARES Act. And so it's everything from, you know, venture capital funds telling their portfolio companies not to apply because this loan program is not designed for them. I think that's on one extreme end of the continuum, over to, you know, people thinking this is free money and we had no plans to fire anyone, but why don't we go grab this because it's forgivable? So from a policy perspective, how are you looking at that?
Yeah, it's a great question. And the problem is, right, it's completely subjective. What does it mean to sustain ongoing operations? And so it's an impossible question. From our advice is, first and foremost, consult your counsel and be sure that whatever you put in, because the banks aren't checking this, be sure that whatever you put in, you are comfortable with, because on the only time that you're going to get an answer as to whether you were right or wrong is on audit. And that's not the time you want to say, oh, well, you know what, that actually makes some sense. So take it very seriously. Blake, I thought you all did a fantastic job of kind of walking through that and saying, listen, like, you got to think about these factors. I agree with you. I think it's a point where, you know, you have these two extremes, both of which are going to have negative political outcomes, right? The extreme number one is you're taking money from, you know, these mom and pop shops. Extreme number two is you're going to be laying people off that those jobs you could have actually saved. I think both of those are kind of negative places to have political risk factors to them, right? Mm-hmm. I will reserve on the legal side, because I think you did a much better job than I, other than to encourage folks to reach out to you with those questions and not to make those determinations to themselves. Make sure that counsel is involved. From a political perspective, what I will say is this. If you do take the money, best practices, you got to look at what you're doing in exec comp. You got to look at what you're doing on fringe benefits over the next year. Because if, you know, like I said, I was on the Hill in 2009, 2010 after TARP. And the number one thing those guys got dinged for was big bonuses within a year of taking federal money. And so if you're, look, I think, Blake, you made a very good point. Employment is paramount, right? There's no doubt that this program is built around employment. But if you want to buttress your case, you can't just say, hey, I would have had layoffs, but, you know, I also, by the way, found the money for a 25% increase in the CEO's bonus, and we ended up building out that kombucha stand we were really looking for. I'm being cavalier, not because I believe this, but because I just I'm trying to put out what the story is going to be down the road, right? We already saw the story from Erin Griffith in the New York Times where she said tech bros are taking the money, and the first thing she talked about was kombucha. So that's why I say it in that glib way, because this is from a political theory perspective, this is a 101 populism kind of thing, right? Us, the pure independently owned small business, versus them, the coastal elite with all their money. And so you're going to get dinged on that, right? The Valley's going to get dinged on. That's going to happen. I think there's some part of this we just got to live with and just make the right choices, make the right decisions. But from a political perspective, as you work through that, understand that it's going to be viewed more holistically. And so don't just think about employment. Think about employment as a paramount issue, but also think about where is your other capital going to? And are you increasing things that upon further reflection might not look as necessary as you thought they did at the time?
Justin, I think that's a great point. And to build on that, I think it really dovetails with a thread that's run through some of the points that Blake and I have both made, which is, yes, call your counsel and get advice on these topics before you apply, but also the need to talk to your board and your stakeholders and make sure that those who are involved in the management of the company, broadly speaking, are aligned on whether or not to access these funds, whether there's necessity there, whether investors and board members are comfortable with the disclosures that are going to be required in connection with the application. I think one of the worst things you can do as a startup founder is to just go apply for the loans without looping anybody in. And we've seen a couple of companies do that because they just feel like they need the money and they want to be first in line. And it's really risky from both an investor management perspective, from a liability perspective. These conversations need to be had at the board level, and the large investor stakeholders need to be looped in as well. And so we've been advising all of our clients in that direction. Yeah.
And to put a finer point on that, you know, under normal corporate governance precepts, you wouldn't necessarily need the board to approve management applying for a loan under normal times, but we're actually advising our clients for the PPP, because of that certification, the necessity certification, to actually call a live board meeting and debate these things and talk about it and actually adopt a resolution that says management is authorized to apply for this loan, and we hereby confirm that it is necessary for ongoing operations in light of this crisis. And it turns out that when you ask a board to vote to adopt a resolution like that, you oftentimes get some interesting conversation, and we've had a couple of clients decide based on that not to apply for the loan.
You know, Blake, I think a couple things that are very meritorious about what you all are saying here. Number one, except for, you know, some percentage where it's quite clear that they are desperate straits, I think if you're not having difficult conversations about this, you're probably not thinking hard enough about it. I think, and then number two, just because it's a really difficult conversation amongst board members and good people are taking different sides in this, doesn't mean anybody's wrong. It means that it's a subjective test in an economic crisis, and it is objectively impossible to have the right decision. You just gotta fight through it and understand your unique facts and circumstances and lay that fact pattern out. I don't think you can have this blanket like, hey, listen, if you just check these 3 boxes, you're good, right? The SBA doesn't work that way, right? The SBA, they work in details. And so that's why I think what you all are saying is so effective, because you want to be sure that you're thoroughly thinking this through, and you want to be sure that you have that well documented in a file that you're ready to be able to grab and present to whoever comes knocking on the door in a year or 2 from now.
That's right.
And it gets back to what Lily was saying around, you know, setting a tone for ethical actions. And, you know, I won't get into Lily knows these issues better than I do around, you know, derivative suits and things like that. But the theory would be, you know, if the board did deliberate these things and adopt a resolution, that they're protected somewhat from a corporate law perspective from, you know, by virtue of the business judgment rule. But Lily, I don't know if you have anything to add around that.
No, it's absolutely right. And I think it's all the things that have been talked about, documenting your file to show the steps that were taken in terms of ensuring the accuracy of all these things, and having, you know, really good, robust evaluation at the board level will all go towards a good defense if you happen to be in the unfortunate position down the road.
I wanted to open it up a little bit to questions that we're getting through the Q&A, and if any of the attendees have other questions, now's a good time to drop them in there. But we got a couple of questions around pre-revenue startups and people who are paying contractors, or a founder who hasn't been paid or just recently started being paid. What does their eligibility look like, and how to position their application?
Yeah, it's a good question. And so for independent contractors, companies are not allowed to use amounts paid to independent contractors for purposes of determining the loan amount. So those have to be excluded. And then technically speaking, you're not supposed to use the loan. I'm talking about the PPP here, by the way. You're not supposed to use the loan proceeds for paying independent contractors. And the policy reason for that was, at least the stated policy reason for that was that independent contractors and so sole proprietors can apply for the PPP separately under the CARES Act. So unfortunately, for companies with, you know, a material number of independent contractors, you're not supposed to use that loan for those purposes. Theoretically, you can use some of the proceeds for them, but it would certainly not be forgivable. And then you're also putting yourself at risk for, you know, audit problems later on. But you know, these, like I said, these programs are available for contractors and sole proprietors to apply separately. Unfortunately, for, you know, this gets to the unpaid founder situation. Unfortunately, the loan amount calculation is based on actual payroll, so amounts paid to service providers. And so if you haven't been paying yourself, then I think you're going to find, at least when the bank helps you do the calculations, that you're not going to be able to, you know, figure out what your back pay would have been and include it in the loan amount.
When it comes to the loan proceeds, though, Blake, whether it's a founder or another employee who hasn't been paid historically, as long as you're using the proceeds to pay employee salaries, they're still forgivable. It doesn't need to map one-on-one to the cost that predicated the loan amount. So not that it's advisable to go take out a loan based on historic employee salaries and start using it to pay founders. We would probably advise against that for, you know, several policy reasons, among others. But there is a distinction between what's eligible to be included in the loan calculation, which is really just actual payroll amounts. It can't include projections or salaries that were expected to be paid in the future, versus what you actually use the loan proceeds for. If you're eligible and you get a loan, you can use them to pay any salaries that fit within the definition.
Mm-hmm. Yeah, that's right.
And how does this relate to equity, like founders who have been paid or paying their staff in equity? I'm assuming that it's similar in the sense that you have to, like, the payroll is actually what you should be framing the application around.
That's right. Yeah. And, you know, it is obviously very common for founders not to take any salary early on, and even to compensate other service providers with equity. Unfortunately, this is a payroll-driven process. But like Laura said, I mean, to the extent you had some payroll and you were able to take down a loan on that basis, you can pay people. The forgiveness amount is really calculated on head count between the measurement period, which is that 12-month period prior to taking down the loan, and the head count on the date that's 8 weeks after loan disbursement. So as long as your head count is not lower than that measurement period, you can get full forgiveness for payroll costs.
And then I see a question around what counts as utilities. So there's a founder who's asking if she could use the loan to pay for software that they use to keep their product up and running, like AWS or other tech.
That is a great question. I don't know the precise answer to that. My sense is, from reading all this stuff for 4 weeks straight, is that would not be included in utilities. The analogy that I heard someone make is that a lot of tech companies have leases, you know, triple net leases, which include utilities, their pro rata share of utilities costs in the building, and it is those costs that can be paid. My sense is that software would not be included in that, but we can look into that.
Okay, great. And I also see some questions around, like, timeline. Like you mentioned at the beginning, that you've heard of some people who have started getting funds dispersed when they were on the earlier side of the application. Can you speak a little bit to that, either Justin, Blake, Laura, what you've heard, what you kind of anticipate? I know it's a little difficult to speak to something that is theoretical, but I think it would help people.
In terms of how long it's taking to get through the process. Yeah. Like I said, people who applied really early, it was taking 3 to 10 days. I just heard this morning that we have a couple clients with JP Morgan Chase who got their funds the next day. In fact, they hadn't even fully processed the loan application and the funds showed up in their bank account. So another example of use your existing commercial banking relationship, because that can really accelerate things.
Well, and the other issue with that too, right, is using your existing banking relationship means they don't have to do KYC and all the other getting to know your customer stuff, which is probably, in my view, the primary reason why these folks are only doing existing clients, right? Because they know they can get those applications through quickly. And if you have such volume, why are you going to spend time with some manual process from someone who's not even your client right now?
Right.
I see another question that's in the chat just around relating back to unpaid founders or pre-revenue startups. Do you all have suggestions of other funds that might be available or just down in the future when you're looking at kind of what's going on the Hill about people who maybe don't qualify for one of these programs, but what might be available later on, or suggestions for other sources of loans or funding?
Sure. Yeah. So, I would just go back again and say, make sure you're not making your employer side of Social Security tax payments right now. That should free up some cash flow. Take a look at the employee retention credits. If you've been shut down, or if your revenues have dropped by more than half, which are the pre-revenue, they may not, but if you have been shut down, you're eligible for that. And it's a lot cleaner process than the SBA. The value is certainly a fraction, but the process is a whole lot cleaner. And those credits are advanceable and refundable, just like the emergency leave credit that was in phase 2, where if somebody needs emergency leave, you get this advanceable refundable credit to help offset their wages. And then third, for these early stage companies, I don't think the Main Street facility, even if we get some of these fixes, is going to be particularly attractive. Keep an eye on what we're doing there, and hope for a something to pop out, but don't expect that. But also, as we go forward, take a look at tax assets, because I do think there's a chance there if we, as a community, rally behind a concept like that, that I think can drive value to pre-revenue companies, because they're still spending money. And if you're pre-revenue, that means every dollar of operating expenses that you're spending is turning into an NOL on your balance sheet, if that makes sense, right? You take $1 million, you spend $1 million, you didn't have a dime of revenue, all that shows up as $1 million worth of losses on your balance sheet.
Great, thank you for that. And I wanted to just end, we have about 5 minutes left, with just general advice that you might offer folks who are on the call, either from the investor point of view or the founder point of view, around what they can look to kind of in the future. I know things are very uncertain right now, and I think we're kind of at the beginning of what could be a recession, and just what you would advise in this time for both folks who are just starting companies, or maybe have never been through something like this, and what any words of kind of like encouragement or reassurance.
So I think Blake will probably have a better, counsel. Blake and Laura probably have better counsel for things, but maybe I'll just put in and say, listen, like, when you're in a crisis, just keep your head, keep thinking, keep pushing forward. Understand everybody is as confused as you are, and that includes policymakers in Washington. So rather than getting frustrated and yelling about things other folks are doing, we're all in this together. Let's work together and do what we can to get out of this, because and just try going forward, because this is uncertain for everybody, even those of us that have seen this before.
Tap into the resources that you do have, whether that's your council, whether it's networks, whether it's another network of fellow founders or startup or venture investors that you're in. If you're a leader of a company, tap into your board, because as Justin mentioned, we're all trying to sort this out at the same time, right? Everybody has questions, and none of it is super clear cut at the moment. And so I think looping in people and getting the feedback and advice that you can from your existing stakeholders and your existing network will help you to make those decisions on how to move forward.
And just to add to that, it's a little too early to tell in terms of the macro environment for funding of private companies right now. I can tell you that existing funds are taking care of their existing portfolio companies first, not surprisingly. And so that's one of the resources you should definitely tap into. I would say, if you have a certain amount of runway, 6 to 12 months of runway, it's not too early to start thinking about, the end of that runway right now, because it is going to take longer to raise your next round of financing, even from your existing investors. Inside rounds are taking a little longer because people are thinking about things a little harder right now, as you can imagine. You know, we're starting to see some, you know, distressed terms in terms of those financings. It's not quite to the point it was in 2009, 2010, for example, yet, but we are seeing investors ask for, you know, better terms, more protection for themselves, things like that. So just expect that. I think it'll start with lower pre-money valuations, and it'll start getting, you know, the terms will start getting more draconian from there. But it really remains to be seen, you know, if this is going to look, is this going to look like the dot-com bust? Is it going to look like the financial crisis? Is it going to be some combination of those things? We just don't know yet. The good news, I think, is that this is different in a good and bad way from those last two crises. You know, the dot-com bust was, you know, it was super frothy. There was very little actual asset value behind a lot of the economic growth we were seeing. And whereas I think that's different now. Unfortunately, we've never in our history had to really turn off our economy like we have, the global economy. So that is causing them a lot of uncertainty. But just keep in mind that, you know, investors and other people in the ecosystem are people too, and they are a little freaked out, and things are going to take a little longer.
Absolutely. I don't think we can hear you. I had this problem earlier with my.
That doesn't help.
Yes, there
we go.
So yeah, just stick to some really basic ethical principles, and I like to think of something I call the Wall Street Journal test. If a story about what you're doing ended up on the front page of the Wall Street Journal, would you feel comfortable that you've done everything you can to make sure that the facts are in your favor?
Great. I love that test. That's great advice. Well, thank you to everyone who was on the panel. I certainly learned a lot, and I hope all the folks who are on learned a lot as well. We really appreciate it. Thank you again. Enjoy the rest of your Monday. But yes, thank you.
Thank you.
Thanks for having me.
Thank you, Katie, for
Thanks so
hosting.
much.